Well, welcome everyone. My name is Camille Wimbish. I'm so pleased to have you all joining us tonight. We are going to be doing the democracy and the courts. This is the second part of our series, and we'll be discussing judicial recusal and ethics tonight. My name is Camille Wimbish. I'm with the Ohio Fair Courts Alliance, and I've got a number of wonderful folks helping me out tonight. Jessica Dickinson, who's our Fair Courts manager, is going to be helping us move the program along. Jessica, did you want to say a few words about the program tonight?
Yes, hi everybody, nice to meet you. So glad you could join us tonight. We have a PowerPoint presentation that we will make available to you after the program. I will, as we go along, be putting links in the chat for additional information, and questions, please, are welcome and expected. Put your questions in the chat. We will be monitoring it, and we will post them to our panelists during the Q&A session.
All right, very well. Let's kick it off then. Tonight, we've got a wonderful panel of co-sponsors who've helped us to promote this event and provide wonderful expertise, including the Common Cause Ohio, Fair Courts Alliance, Freedom BLOC, ACLU, Brennan Center, and others. And as I mentioned, this is sort of our, this is a series of 3 webinars. Common Cause Ohio and the Ohio Fair Courts Alliance have teamed up to present a series about, what's happening to our courts and our democracy. And the goal really tonight is to start to look at opportunities and challenges for shaping our courts, as well as developing a really shared agenda so that we can sort of try to chip away at structural racism, money in judicial races, and ethical standards. So this will be the second part of the series, and we will be giving you information about our upcoming webinar just next week. All right, so I just wanted to say a few words about tonight's event. Many of you on this call have no doubt been following along with Ohio's redistricting process, and you're aware that there are maps that are being challenged to the Ohio Supreme Court. In fact, the question of whether Supreme Court Justice Pat DeWine should step aside from hearing those redistricting cases involving his father, Governor Mike DeWine, that has certainly been in the news. And some of the participants in tonight's webinar are actually involved in that litigation. And so, it's very common that parties involved in litigation would not be commenting on their case. And in fact, judges infrequently recuse themselves. So as we think about this upcoming case before the Supreme Court, just know that today's participants that are involved in the litigation will not be directly addressing the case about redistricting or and so there will be others, of course, will be providing context around our situation though. So, next slide.
Come on.
Camille, I'm sorry, I had to mute you there, so you'll have to unmute yourself.
Great. So we're joined tonight, we will be moderated tonight with Karen Shiwi. She is the program strategist for Repower, which is a national capacity building and training organization that partners with progressive orgs around the country. And for the last 5 years or so, she's actually been super helpful in developing the Ohio Fair Courts Alliance and working with other national groups to develop a fair courts plan. So she was, of course, our first thought and for who could help us moderate this discussion. So next thing you'll hear from me, you've got panelists who are going to be giving about 10 minutes of remarks. You may be chiming in to let people know that they'll have 2 minutes or so to wrap up their remarks. But Karen, why don't you kick it off?
Thanks, Camille. I love that bell, and I'm honored to be here tonight. As Camille mentioned, our main topic tonight is exploring the need for a stronger judicial code of ethics, which seems very timely for Ohio, particularly around judicial recusal and disqualification standards. And we'll also explore how special interests influence the judicial selection process and decision-making. But first, let's make sure we all have the same idea of what recusal means. It's one of those legal terms. Do we have any football fans in the audience? So as everybody knows, the role of umpires, similar to judges, is to make fair decisions when two teams disagree. And that's happening a lot lately in the country and also in states. Umpires and judges have the power to call the shots, and they have the final word in these situations. Say you're lined up to be an umpire for a game between the Ohio Buckeyes and the Michigan Wolverines. I hear there was a game like that not too long ago. And your son is Cade McNamara, a star quarterback for the Wolverines. If you were this umpire, you might step down because under the circumstances, you believed it would be difficult for you to make fair decisions. Or even if you thought you could be fair, you might still step down because you wanted to avoid the appearance of being biased. This is what recusal means. Basically stepping away from a decision where there might be either the appearance or the actual reality of a conflict of interest. The topic we're focusing on tonight is timely, given the current scenario surrounding Supreme Court Justice Pat DeWine, who many might have heard about. In Ohio, judges are not required to recuse themselves, even if they're deciding cases that concern their own campaign contributors or family members. Rules governing judicial ethics, including the circumstances under which judges should recuse themselves, vary from state to state, and some are stronger than others. As many of you know, Supreme Court Justice Pat DeWine is currently presiding over a case about the newly drawn redistricting maps that his father, the governor of the state, voted for. It will be his job as one of the members of the Supreme Court to decide whether these maps are fair and equitable for all Ohioans, or whether they'll need to be changed. And this case goes before the Ohio State Supreme Court next week on December 8th, and Justice DeWine has refused to recuse himself. This example is one of many across the country where judges are presiding over cases in which there are actual or perceived conflicts of interest. And our panelists tonight will talk about other examples, including a current case in North Carolina. So very few people know that 95% of all court cases in the country go to the state courts. We think of the Supreme Court at the national level as the main decision maker, but this isn't the case. And as more of these cases come before our courts across the country about redistricting, access to the ballot, reproductive rights, environmental regulation, and more, learning more about the rules governing judicial ethics, including recusal, is critical. And that's why I'm excited to introduce this panel tonight. We'll begin with remarks from our four great panelists, and then open it up for questions, and then discussion, and end with some ideas on how you can get involved. So I'd like to introduce the panelists, which I'm really excited about, and I know many of you. Billy Corriher is a writer, consultant, and advocate for fair courts. He writes about judicial selection, voting rights, and the courts for facing south. And Billy has also written about these issues for Think Progress, The Hill, USA Today, the Los Angeles Times, Newsweek, and more. His new book is titled Usurpers: How Voters Stopped the GOP Takeover of North Carolina Courts. Billy's going to share a video that demonstrates some of the major issues we're grappling with in Ohio and really across the country. Talk about firsthand impact of not having judicial recusal standards, and share what's currently happening in Ohio and North Carolina. Then we have Judge Jeremy Fogel, who's a former U.S. District Attorney for the Northern District of California. He's currently the Executive Director of Berkeley Judicial Institute at Berkeley Law School, and he specializes in judicial administration, ethics, unconscious bias, and the politicization of the judiciary. Judge Fogel will give a framework on judicial ethics and what to expect from the court, and talk about how to promote an ethical and independent judiciary. Doug Keith is counsel at the Brennan Center's Democracy Program, where he works primarily to promote fair, diverse, and impartial courts. And before this, he was at the George A. Katz, he was a George A. Katz Fellow at the Brennan Center. And his work has been featured in the New York Times, Washington Post, NPR, Atlantic, Guardian, New York Daily News, and Huffington Post. Doug will discuss the importance of having a fair and independent judiciary, the role of the courts in democracy, and recent polling. And finally, Sarah O'Brien is a retired Dane County, Wisconsin Circuit Court judge. She was elected in 1992 and re-elected in 1998, 2004, and 2010, which is a great accomplishment, and served in all divisions of the court, family, juvenile, criminal, and civil, and presided over drug treatment court. Since retiring from the court in 2012, Judge O'Brien has continued to be active in court improvement activities, as well as serving frequently as a reserve judge and mentor to new judges. Judge O'Brien will discuss her experience with the 2017 Wisconsin Judicial Recusal Initiative, which I was honored to be a part of and watch, and talk about how a petition can be used as a tool by states for judicial recusal reform, and also share what worked and what didn't work. And at this point, I'd like to turn it over to Billy.
Thank you, Karen. Hey, everybody, Billy Corriher, for those who don't know me. And we're going to start actually, well, I will tell you a little bit about myself. For those who don't know me, I'm a writer and an advocate for fair courts based in North Carolina. And up until a few years ago, I was actually working on those issues in DC. I was writing a lot about the need for stronger recusal rules, especially given the amount of money that we had seen coming into judicial elections. And I wrote about the need for stronger rules in Ohio, Wisconsin, and a lot of other states where we were seeing a ton of money coming into judicial elections, but the rules weren't keeping pace with all of this money that was coming in. In fact, the rules are pretty vague when it comes to when judges have to recuse themselves, especially in cases involving campaign contributors. Only a handful of states have specific guidelines that say judges can't hear cases involving campaign contributors above a certain level. In most states, judges are sort of left with this vague standard that says you can't do anything, you can't hear any cases that would risk appearing biased. As someone said earlier, you know, these ethics rules are not just about preventing bias, but they're about preventing the appearance of bias. So a judge is supposed to look at a conflict of interest and say, would this make me look, you know, unbiased? And if so, they're not supposed to hear the case. That's the rule in just about every state. But in Ohio and other states, it's left up to the individual judge to decide when hearing a case might make them appear biased. And that's where I think you have a lot of the problems that come into play. In some states, they have a different system where, you know, the court as a whole decides, not the individual justice or some outside body or outside court makes the decision, but not in Ohio. And that has led to a lot of conflicts of interest on the court. And, you know, if you followed Ohio politics, you know that one of the biggest campaign donors is First Energy. And if you look at judicial elections, that is, that's no different. The energy utility companies and their lawyers have poured a ton of money into Ohio Supreme Court elections. And that's what we're going to watch a little video about that. And this video came out, I think, in 2014 or 15. And at the time, the Ohio Supreme Court was deciding whether localities, counties and towns and cities could regulate fracking. And as you can imagine, when they were hearing that case, a lot of fossil fuel interests were interested, and they spent a lot of money on that. And that's what this video is about. So Mia, if you want to play the video, it's only about 90 seconds. And it shows a family that was impacted by fracking pollution. There should be sound.
Fracking waste. You know, imagine a little tiny town with a nice farm that's outside. Imagine you have no rights whatsoever as that organic farmer. We do live in a state where judges are elected. And just like every other politician, our judges receive campaign contributions. And it's really hard to imagine someone giving money to the referee in the middle of the game. And yet that's exactly what we do when it comes to our Supreme Court judges.
I can't protect my community because the rights of the township has been taken away. I'm not against gas and oil. Okay, it's got to be done, but it's got to be done safely. Are those chemicals eventually going to reach the aquifer? And that's what we fear. Every day when the people in that area get a drink out of their faucet, the question's got to be there. Am I drinking chemicals?
Thank you, Mia. Yeah, that video, there's a longer version, I think Catherine may have shared the link, and it actually includes an interview with a family who experienced some pollution on their land. And I want to briefly, before we move on, mention, Karen talked about a different kind of conflict of interest on the court, and that is Justice DeWine hearing cases involving his father. A couple things I just wanted to point out is that Justice DeWine actually recused himself this past fall when he was facing another case involving his father, and he said it was explicitly to avoid appearing biased. But now that the court is hearing this redistricting case, he has changed his mind and decided that he wouldn't appear biased by hearing a lawsuit against his father. But again, the rules are very clear when it comes to conflicts of interest involving your family. When it comes to campaign cash, it's pretty vague, but when it comes to your family members, the rules are very, very clear. And it says that you can't hear cases involving your relatives. And that's not just your immediate family. That includes like cousins and nephews and nieces too. So it's a clear conflict of interest, but like I said, in Ohio, it's up to DeWine to decide. And here in North Carolina, we have a very similar conflict of interest on our state Supreme Court. We have a justice who's named Phil Berger Jr., and his father is Phil Berger Sr., who's the head of our state Senate, and the defendant in a lot of lawsuits over gerrymandering and voter ID laws and other things. And just like DeWine, Justice Berger actually recused himself last year when he heard a voting rights lawsuit against his father. He didn't say why, but when the when he got to the state Supreme Court this year, and he's got another lawsuit in front of him against his father, this time he's decided that he's not going to recuse himself. But unlike in Ohio, it's not really clear how this is going to turn out for us because the court hasn't decided whether Justice Berger gets to make the call or whether the court itself is going to decide whether he can hear the case. They've actually asked the parties to this lawsuit to submit briefs on the issue. They've had amicus briefs coming in from law professors and experts on judicial ethics. And most of the people weighing in are weighing in favor of a system where the whole court decides when there's a conflict of interest and not just the individual justice. And I'm confident that the court is going to agree that it's best that the court as a whole decides, but we are still waiting to see how that turns out. I'm confident that whenever the court does decide that they're going to do the right thing and that they're going to set up a system where the individual justice, the one that has a conflict of interest, doesn't get to make the final decision. But it's unclear right now what's going to happen. So hang in there and we'll find out. Oh, and I wanted to mention too, our state legislature has engaged in a series of attacks on our courts because right now our state Supreme Court has a 4-3 Democratic majority, and they've stuck up for voters in a lot of cases. They've struck down gerrymandered election districts, and that has made the legislature very angry. And right now, there are actually Republicans in our state who are saying that if the court votes to disqualify Justice Berger, they are actually going to impeach the justices who vote to do this. They've made this similar threats before, so I don't know if they're actually going to follow through with it, but it's the kind of thing, it's been pretty amazing to see them react in such a strong way to what the court is trying to do here when, really all they're trying to do is enforce their ethics rules. The rules are clear. You can't hear cases involving your parents, but, some justices just don't get it. So I think that's all for me. But if folks have questions later, we can get to it.
Thank you very much, Billy. So we're going to move to Judge Fogel.
Judge Fogel, if you are muted, you will want to unmute yourself.
Okay, it's the last time you're going to have to ask me to unmute. What I was going to say is this is, first of all, I'm very happy to be here. Secondly, this is a critically important topic, and it's one that has many layers of complexity. I mean, you can look at the extreme cases and you can say, well, there's no way that this should ever be allowed to happen. And then there's cases where there's gray areas and cases where what ought to happen isn't clear. And you have different sources of authority. And so what I'd like to do in the brief time I have here is just sort of give you the framework for where these ethics rules come from, what their sources are. And then I think maybe that'll help frame the subsequent discussion. So why don't we move to the first slide? The question is, where do we get our ethical standards? You know, what are the rules? Where do they come from, and who's accountable to enforce them? So let's go to the first bullet point. So one of the major sources of ethical standards is legislation. In a lot of states, the code of conduct that applies to judges is adopted by the legislature. And so they actually will lay out what the standards are. That's not the only one, but that's not infrequent. And it's also possible through legislation to make specific requirements, financial disclosure reporting, which is common in both the state and the federal systems. Those usually are a result of statutes. The legislature passes a statute and it says you shall disclose this at such and such a time, and the public will have access to the disclosures in such and such a way. That usually is done legislatively. And so that's an example of how legislation can work. And then a point that we just heard about having to do with who decides disqualifications, whether it's the judge who's been challenged or whether it's somebody else, whether it be the whole court or a third party. That's usually done by legislation. I was a state judge in California for 17 years. And if somebody challenged me or challenged one of my colleagues, I could not decide whether the challenge was valid or not. I had to refer it to someone else. And another judge, and quite often it was a judge from a different county, would look at the facts and look at the showing and determine whether there was any basis for disqualification. So that's another way to handle it. And that's all provided by legislation. So the legislature is one of the major sources of ethical standards. The next. Okay, well, it's fine to put, codes of conduct. So codes of conduct are, as I said, they can be mandated by the legislature. They also can be adopted by the Supreme Court, or if the state has a judicial council, then they can promulgate the code of conduct. Every state does it a little bit differently. There is a model code of conduct that was put out a long time ago by the American Bar Association that a lot of states build their ethical standards off of, but ultimately it's up to each state to decide how they're going to adopt their code of conduct and what's going to be in it. So then that becomes the major source of ethical standards. So the next one is case law. So you get, as I said, frequently you'll get gray areas. What does it mean that a judge can do this or can't do that? And what happens in a particular case? This is kind of how the law works in a common law country like ours, that you have the rules and then you have each case where the question is asked, well, how do the rules apply to this particular set of facts, these particular circumstances? And so there's a lot of case law about disqualification, actually. If you look in the laws of each state, if you look in the federal cases, you will find opinions and declarations as to what the proper interpretation of a particular ethical canon is, or what a judge can and can't do in a particular circumstance. So case law is an important source. And I'm going to mention a case that you heard about, I'm sure, that may be somewhat illuminating about what's going on in Ohio and in North Carolina. So if you remember the the hunting situation where Justice Scalia and Vice President Cheney went hunting together. And it was at a time when there was a case before the Supreme Court, US Supreme Court, in which the vice president was a party. And the court did not hear the case formally, but Justice Scalia declined to recuse himself. And what he said was that, Mr. Cheney is a defendant in his official capacity, not his personal capacity. I'm not deciding a case where, whether he or his neighbor is right about the property line or something like that. I'm deciding a case as to whether the office of the vice president can do X, Y, or Z. So you see, lawyers and judges make those kinds of distinctions. And sometimes when you think about a particular disqualification situation, that nuance has to be considered. But that's the kind of case law that we have. All right, and then what I did here is I simply, and I don't want to leave out this last one because it's really important. So tradition and social context, this is the culture in each community, in each court. And in some states, there's a very robust expectation about recusal and disqualification. It tends to be pretty strong in California. And in some states, it really doesn't happen very much. And I think that's part of what Ohio's dealing with, North Carolina's dealing with, West Virginia, other states, and particularly states that have partisan elections. And I'll get to that in a second, but there's not a strong tradition of judges recusing themselves. And then social context, by that I simply mean, where are you? Are you in a small town where everybody knows everybody and it would be virtually impossible for a judge not to know the parties? Or are you in a big city where there's a lot of anonymity and there's a lot of judges and it's possible to get a decider who doesn't have any connection to any of the parties? And I think that makes a difference. And also the question of partisanship makes a difference. Ohio has partisan elections for judicial positions, and so does Wisconsin. We'll hear shortly about that. And that affects the climate, the atmosphere in which these kinds of decisions are made. And then one other thing I'll mention, and it's about judges, and I was a judge for a really long time. And one of the things I learned about judges is that judges really want to believe that they're fair. It's very hard to get a judge to just say, you know what, I'm not fair, I'm biased. I'm not able to decide this case fairly. Judges have a very hard time getting to that point because it's a point of pride, and it's really one of the major values of the judiciary. And so having a judge be the determiner of his or her own disqualification is problematic in that sense. It's hard to get a judge to say, you know what, I'm really not going to be fair here because I know one of the parties or I'm related to one of the parties. And so what tends to happen is you get these kinds of distinctions. Well, my dad's being sued in his official capacity and not his personal capacity. And the issue I'm being called upon to decide is an abstract legal issue and not a personal one. So therefore there's no conflict. That doesn't deal with the issue of appearance of impropriety, which I'll talk about in a second, but it's I think a little window into how judges think. Okay, let's go to so what I've done here is this is from the federal Code of Judicial Conduct, and pretty much all of the states and the federal judiciary have similar ways of stating what the basic ethical principles are. And I'm not going to dwell on them. I just want to give you some idea that this is what the courts and judges this is what they say that they're aspiring to. This is what they're trying to do. And the ones that really matter for the conversation we're having here is avoiding impropriety and the appearance of impropriety. You don't want a reasonable person to think that you might be doing something improper. And of course, there's the duty to be impartial. And again, those are things that, they're in the eye of the beholder, but one of the things that judges are required to do by just about every code of conduct is to try to think about not only how they see it, but how somebody else might see it. Okay, we'll go to the next one. So how do you enforce these standards? Well, in just about every system, the way this sometimes gets resolved is that the higher court, usually the apex court, the Supreme Court, will clarify a cloudy or uncertain issue of ethics. So you'll see if you go through the the case books, you'll see cases that talk about judges' duties of recusal and what is a disqualification situation, and that gives you some guidance. Next. Yeah, so in most states, the primary way that you enforce ethical standards is the states have judicial disciplinary bodies, or they have judicial councils, which are made up of representatives of all the different levels of the judiciary. And they opine as to whether what somebody did violated the underlying principles of the codes of conduct. And these are pretty significant bodies, but they differ in how potent they are depending on where you are. So in some places, judges who do not timely recuse themselves in cases where there's appearance of impropriety have ended up being significantly disciplined, and in some cases even removed from the bench. And in others, it's just sort of assumed that it's up to the judge, and we're not going to question the judge's judgment as to whether they should have recused or not. And there's a wide variety. There's a case from the US Supreme Court from West Virginia called Caperton, where I talked about this, and it involved campaign contributions. And the Caperton, who was the petitioner in that case, had given so much money to elect particular judges to the West Virginia Supreme Court. The Supreme Court said, well, I don't know where the line is, but I know that this is over the line. They said that it was too much. It undermined the legitimacy of the court to allow that contribution to stand, and for the judges who had received them not to recuse themselves. But that case is something of an outlier. It took a very, very extreme situation for the US Supreme Court to get involved and say, no, this is something that's just beyond the pale. A judge can't do it. The next.
Good morning.
Thank you. I'm almost done. So go back to the social context, and that is, how do you enforce ethical standards? And I think one of the purposes of this gathering is to think about that. And I think elections, and it's my personal view, and people can disagree with me certainly, but I think judicial elections cause a lot of mischief. I think they cause a great deal of problem in this area of propriety, impropriety, effective campaign contributions. Partisan elections are that on steroids. But I think one of the other advantages of elections is that you can push back. If you're organized and you say, wait a minute, this is too much, this undermined the kind of judiciary that we want to have, this allows people who have different political views to get involved and get engaged. So it's an important point, if you're in a jurisdiction where judges are elected, that you have power. You don't have to just kind of sit back and take the results if you don't like them. You have power to get involved as well. Thank you.
Thank you very much, Judge Fogel. We're going to go to Doug Keith now.
Great. Well, thank you so much for having me. Again, I'm Doug Keith. I'm a counsel at the Brennan Center for Justice. We are a law and policy institute based at NYU School of Law. And Mia, can you advance this slide, please? So my fellow panelists, as you've heard, have really a wealth of information as to what judicial ethics rules can and should look like. I want to take a few steps back and just speak briefly about why this matters, why our democracy requires strong judicial ethics rules. And the first thing to recognize is that in our democratic system, courts are tasked with serving as a check on the other branches of government, ensuring that those other branches do not overstep their authority. That's a pretty important responsibility. And yet our system gives courts far less power to enforce their decisions than it gives these other branches. If you'll indulge me, I'm going to quote Alexander Hamilton here, which is on your screen, explaining how courts have comparatively little power. As you wrote in the Federalist Papers, the judiciary has no influence over either the sword or the purse, no direction either of the strength or the wealth of society. It may be truly said to have neither force nor will, but merely judgment. All he's saying here is that all the court has for its authority is its opinions and the expectation that other government actors are going to adhere to those decisions, even if they dislike them. But why would other government actors follow court decisions if they dislike them? Mostly it's because the public expects them to. Sometimes they even demand that they follow court decisions. So particularly in a moment of crisis for our democracy, in which courts are an essential line of defense against anti-democratic forces, it's really essential that the public continues to think that court decisions are worth following, because ultimately that public trust, that public confidence, that's where the court's power comes from. Next slide, please. So let's talk a little bit about the state of public's trust in courts and the crisis moment that we appear to be in. Polling really shows a steep decline in public confidence that suggests we're in a really unique moment right now. Gallup poll from this year found that only 54% of Americans have trust in the judiciary. This is down from 68%, which is the 20-year average over the last 25 years. A poll about state court systems found that only 65% of respondents had confidence in state court systems. This may seem like a high number. How do what do you get 65% support on anything these days? But that's an 11% decrease from 2018. And specifically, less than half of respondents to that poll thought that state courts were unbiased. And then new polling out this week found that only 32% of the public thinks that the US Supreme Court makes decisions based on law rather than politics, which should be really troubling, because to most people that we're going to be talking to, a court is a court is a court. And if they are losing confidence in the US Supreme Court, they're probably also losing confidence in our state and local courts. Next slide, please. And so we shouldn't really be surprised at the public's waning confidence. In the last 2 years, there have been national investigations, and I think some people spoke about this in the chat, shining a light on widespread misconduct and a lack of accountability for judges, both federal and state. I'm sure many folks saw from just a few weeks ago the Wall Street Journal series about the hundreds of federal judges who heard cases in which they had financial conflicts of interest, despite clear rules saying that they should not hear those cases. Fewer folks may have been aware, but I think this was last year or the year before, Reuters did an extensive investigation and found thousands of state and local judges who had violated their state codes of conduct, with behavior that had actually been identified as violating the state's code of conduct, but there was no accountability for the vast majority of these judges. Thank you. And the one more reason that sort of we shouldn't be surprised by declining public confidence is, as the other panelists have spoken to, the reality of modern judicial elections really only makes matters worse. 38 states elect their state Supreme Court justices, like Ohio does, and the Brennan Center for 2 decades has tracked spending in these elections. As this chart shows, these elections have changed over the last 2 decades, such that in 1999, 7 of those 38 states had a sitting justice who'd run in $1 million election. But now that number is around 20. So most states that hold elections have seen at least $1 million race. And this is all adjusted for inflation. I promise I'm not fudging the numbers here. And this money really, it puts every judge on the court on notice that their next election may be the one where the money really matters. And to be sure, when we're electing judges, when you decide that your sort of way of selecting judges is going to be elections, we should expect some money to enter the system. Systems of public financing would be preferred. But either way, you should expect that some money will enter the system. But what's so troubling for public confidence is where the bulk of the money is coming from today. While much of the spending in these races is deliberately obscured from the public, so the public can never really know who's trying to influence its courts. What we do know tells us that often people or businesses with a very specific financial stake in a very specific court decision are the ones putting 6- and 7-figure sums into these races. These are the people and businesses who are trying to influence who sits on state courts. And in some instances, these donors they're going from giving 6- and 7-figure sums to the outside interest groups that engage in these races, and then they'll actually appear before the judges that they supported. And then these interest groups also just generally change the tenor of races. In our research, we found they are far more likely to run misleading attack ads on judges, something Ohio saw a lot of in this last election cycle. And these ads distort the public's view of the justice system, all just for the financial benefit of these individuals or businesses who are very sophisticated political spenders, and they know exactly what they need to put in their ad to get judges' attention or to get voters' attention. So with this reality, the documented misconduct, judicial elections, the politicization of the US Supreme Court, it's really a lot to expect that the public would maintain its historic levels of trust in the judiciary. And specifically the money, again, polling supports this. We did a poll to see how the money was affecting public confidence. And 90% of polling respondents, just members of the public, said that they thought money in judicial elections affected judicial decisions. Heck, 50% of the judges that we surveyed in the same poll said that they thought money affected judges' decisions. And so, again, the question, we don't even need to think about whether there actually is a conflict of interest. It is a problem enough that there is the public almost universally thinks that there is a conflict of interest here. And so just to sum up, if courts are going to be a meaningful check on the other branches, it is essential that we come up with ways to inspire confidence in their decisions. So the public actually sees a reason to demand that their leaders follow court decisions going forward, especially in moments of crisis, as we expect to see in the coming years. So I'll leave it there, but I'm happy to talk more in the Q&A portion of the event.
Thank you, Doug. I'm happy to introduce Judge O'Brien, who will talk about an effort in Wisconsin that we thought was really promising. There are some actions that we can take. So let's go to Judge O'Brien.
And you may need to unmute yourself.
Thank you. I'm very happy to be here tonight. I'm very impressed that there's almost 100 people in the audience tonight. And I think that it's citizens like you that are going to save our democracy in this country. Next slide. I think this topic of money in influencing judicial decisions is one that the public can really readily understand. And I think that's important. There's so much about judges and judicial elections that's kind of obscure and non-political and people don't really get it. But I think everybody knows off the bat that a judge shouldn't accept a lot of money from a party who's going to appear in front of them. I'm going to go to the next slide and then skip it and go to the next one, because that was pretty much covered. So we have a terrible rule on recusal in Wisconsin. In 2010, two of the big independent expenditure groups, the Wisconsin Realtors Association and Wisconsin Manufacturers and Commerce, actually drafted a new rule and the Supreme Court adopted it. Each of these groups had already spent millions on electing Supreme Court justices. And then they approached those justices and said, this is the ethics rule we want you to adopt. Next slide. So the so-called ethics rule said that a judge shall not be required to recuse himself based solely on receipt of a lawful campaign contribution, including a contribution from a party involved in a proceeding before the judge. And it even went on to say that a judge's campaign committee can solicit contributions from lawyers and entities that are involved at that time in cases before the court. Next slide. So this was a big break from the previous understanding, which was that if a contribution was large enough, a judge or justice should certainly consider recusing because it had that appearance of impropriety. I think, can you go back one? Okay, sorry. And now they're saying that no matter how large a campaign contribution is, that is not reason standing alone for a judge to recuse themselves. The rule was widely criticized by newspapers across Wisconsin, and as you've already heard, it violates the principle the US Supreme Court laid out in Caperton case, which was that a very large campaign contribution from a litigant can actually violate due process, and that judges should be required to recuse under those circumstances. Next slide. So what happened next was in 2015, Wisconsin Governor Scott Walker had a recall election, and there were allegations that he had violated criminal laws by having his campaign cooperate with outside expenditure groups. And so something like a grand jury was begun. It's called a John Doe investigation to figure out whether Governor Walker and these outside groups had violated campaign laws. Several of the outside groups had spent $3.5 million in support of the election of one of the justices and $3.2 million in support of a second justice's election. But when this John Doe investigation came before the Supreme Court, neither justice recused themselves. And of course, under that rule written by these outside interests, they didn't have to. I retired from the bench in 2012, but I continued working as they indicated on issues about the court. And in that year, I decided to speak at a judicial conference to all the retired judges and about this John Doe case and how the corruption was just so blatant. I was pretty emotional. I said it broke my heart that the ethical principles I had sworn to uphold and that my colleagues and I had lived by throughout our judicial careers had been just tossed out by the Supreme Court. Justice Gableman, who was in the audience, laughed, and that was extremely motivating to me. So over the next few months, we organized a group of about 60 retired judges, and we had 1,100 total years on the bench, and we decided to file a petition with the Supreme Court to change that recusal rule. We had a lot of help from the Brennan Center, where Doug works. Next slide. So our petition suggested a recusal rule with a set dollar amount, and not everyone agrees with that. I think there's a lot of different ways to approach this, but we wanted a very bright line as opposed to this vague standard of whether there's an appearance of impropriety. So we picked a number for each level of judge that wouldn't require recusal very often. There are not very many individual contributions at that time of $10,000 or more for a Supreme Court candidate. So it would really only require recusal from these very big donors. To facilitate it, we would require the attorneys to actually file affidavits listing what contributions had been made to the judges. And if a judge or justice refused to recuse, here in Wisconsin, it is the decision of the individual judge. We proposed a review by a second party. We filed that petition in January of 2017. Next slide. We organized to contact all the newspapers. There was a lot of support for the petition in Wisconsin. Next slide. And actually across the country. Next slide. On April 20th, a preliminary hearing was held on this petition, and on a 5-2 vote, the petition was denied without a public hearing. So it went down in defeat. The justices spoke out they were very pompous about saying this would violate First Amendment freedoms to make campaign donations, which it clearly doesn't. And there's a lot of law about that. Next slide. At the next judicial conference, we made our feelings clear about this. These are a couple dozen of the petitioners wearing t-shirts that say recusal,
right to justice, not a right to a justice. You don't get to buy the justice that's going to hear your case. Shortly thereafter, the same conservative majority in the Supreme Court decided they would no longer pay reserve judges for required judicial education, which was pretty blatant retaliation for filing that petition and pointing out their corruption. So in 2018, my nemesis, Justice Gableman, decided not to run for re-election, and a trial court judge who supported our petition was elected. And in 2020, a second trial court judge who supports more ethical, more strict rules for recusal actually defeated one of the incumbents. Next picture. And you can go to the next one. This is actually Dan Kelly in the pocket of the campaign donors. That's the one that got defeated by one of the judges running, which is pretty unusual for an incumbent judge to get defeated. So it was a big deal. There's a third of the judges up for re-election who will probably retire because of her age in 2023. So we could actually gain a majority on the court again if we can elect one more justice. So lessons learned, it's hard to get judicial ethics to change by counting on justices who owe their elections to massive spending campaign by the outside interests we're trying to control. However, the voters get the last word at the ballot box, and the voters of Wisconsin understand and are very concerned about judges' decisions being bought by campaign contributions. So I have hope that in the future, we will be able to reverse the course of this. That's it.
And Karen, now you're muted.
Yes, I know. It's contagious. Thank you, Judge O'Brien. And I just wanted to say that was a very inspiring campaign. And I hope to see more like that, even though it didn't win. So we'd like to open it up for questions at this point, and I'm going to turn it over to Camille, and we'll probably toss them back and forth. Camille?
All right. Well, so it seems like there's been some good banter back and forth in the chat, and I've noticed that folks are kind of outraged that Ohio doesn't have stronger rules besides these vague disqualification standards. And so one question is, what is it going to take to actually change the recusal rules in Ohio? Does the legislature play a role in that? And how might the public or other allies be able to pitch in? Let's see, who would be a good person for this one? Maybe how about we go to Wisconsin and hear what allies you had in your fight in Wisconsin?
Common Cause has been very supportive. And I know Common Cause is a member of your Fair Court Alliance. In fact, I'm really impressed by this Fair Court Alliance and think we need one in Wisconsin. They actually, after the fact, put on panels across the state on the recusal issue. The press have been very supportive, and I think every newspaper we went to actually ran an editorial in favor of our petition. And as I indicated, the Brennan Center was also extremely helpful in drafting the petition. League of Women Voters has also done a lot of work around this issue. So there's quite a few fair justice groups and allies out there if you go looking for them.
Yeah, and I know, this is Billy. I remember from that campaign that I believe Common Cause, in addition to petitioning the court and supporting that effort, has lobbied the legislature to strengthen judicial ethics rules in Wisconsin. We've had a similar situation in North Carolina. We've lobbied both the court and the legislature to strengthen judicial ethics rules. So I think really, I think Judge O'Brien and Judge Fogel both mentioned that if you're in a state where judges are elected, you have the opportunity to ask candidates about this issue. Normally, you're not going to ask judges about decisions that they're going to make on the bench, but when you're talking about drafting ethics rules, the judges are sort of making policy, right? They're saying what is the best policy or not, who should win in this particular case. So it's a little different. It's okay for folks to lobby judges on this issue, the way that they did in Wisconsin and the way we've done here in North Carolina.
If I could just add a 30-second comment.
Please.
One of the things that seemed really smart about the way things were handled in Wisconsin was to get retired judges involved. I mean, these are people who've been there, they've done that, they understand the trade-offs that are involved in daily life, and it can be very convincing to the public to have people. It doesn't have to be personal, it doesn't have to be an attack on anyone. It can just say this is what judging with integrity looks like.
I will say that we spent a lot of time debating whether we should try to get sitting judges to join us. And we were retaliated against in such a small way that we lost pay for 2.5 days a year, which is, not going to hurt anybody. But sitting judges could be retaliated against in so many more important ways that can really affect their career, their choice of what they want to do as a judge. And we just thought it was smart for us retired judges that were pretty insulated from any ill effects to carry the flag. And so we never did go to the sitting judges.
Yeah. So retaliation is really a big issue in this whole situation. And one of the questions we have, which relates to Ohio, is if a judge refuses to recuse himself, for instance, Judge DeWine, what recourse do plaintiffs have? What are some general examples? And what about the example in Ohio? Billy, you might have some insight about that.
Well, I mean, unfortunately, there's not a lot that the litigants can do once whatever the process the court has is over. In Ohio, it's just what does the justice decide? But I think there are judicial ethics watchdogs in every state. Here in North Carolina, it's called the Judicial Standards Commission, and folks can file a complaint there if they think that a judge has violated ethics rules. So basically, there can be accountability after the fact. If a judge hears a case that he or she shouldn't be hearing, they can file a complaint with the commission, and the commission will investigate. And depending on the state, that process may or may not be transparent. Often the process isn't public unless the commission finds that there's a violation. But it is an avenue for folks who think that judges are violating ethics rules.
Thanks, Billy.
In fact, I think, Catherine in the chat mentioned that Pat DeWine actually had a complaint against him for hearing a case against his father. And that was a couple of years ago, I think.
Mm-hmm. Camille, is there another question?
Yeah, I'm glad you mentioned the watchdog, media watchdogs. I was wondering if folks, particularly in Ohio, might be able to speak to whether or not there's some kind of public record of, whether or not judges are recusing themselves. How can regular folks sort of keep tabs on, on to what extent this is happening, or how can folks sort of hold judges accountable? Does anyone have any ideas about that?
Well, I know here in North Carolina that the court is not very transparent about how they handle these issues. So it's very hard to find this information. As we found out, now that we're dealing with this conflict of interest, it's hard to figure out how the courts interpreted these rules in the past. I don't know about Ohio, though.
I'll just say nationally, it's one of the great shames of judicial ethics rules that recusal is so opaque. And one of the things that we and many others advocate for is that whatever your judicial recusal rules are, judges should have to respond to recusal motions on the record in a way that the public can be aware of. And that's just not the case in many, many states.
Yeah, I think that's right. And there are a few states. I mean, I certainly don't think my home state was perfect in this area, but you have to, if you have a recusal motion, you have to deal with it on the record. You have to explain what you're doing with it. It can be a 2-sentence statement, but there has to be something that someone with access to the public records could look at. And that's pretty important.
There's another related question. What is the what is the disciplinary commission in Ohio? Who's responsible for actually overseeing this and disciplining judges? I see people like shaking their heads.
I put in information about the Office of Disciplinary Counsel into the chat.
Okay.
I took a look at that, and I thought it was notable that, like, you can't tell who's on the commission. It tells you that there is one, but I don't know who I would contact besides the general number, like who is actually making those decisions.
That sounds like a good place to start.
Yeah.
I'm also seeing, lots of folks saying, do we need a watchdog group? What do we need to do in Ohio to get more accountability and more transparency? I mean, frankly, just knowing what's going on would be the first step.
Yeah, well, this is another place that you can do things by legislation. You can do things using the electoral process. We had a largely secret Judicial Performance Commission for a long time. California has referendum and initiative, and there was a voter initiative to open up the commission and change its membership and make all of its proceedings public once there was a finding that there was probable cause to believe that a judge had violated the rules. And it's been operating on that basis for about 25 years now. and the world has not come to an end. And you know who the members of the commission are. They issue an annual report. They talk about the ways that judges get into trouble. Failure to recuse is not at the top of the list. Actually, the most significant sustained complaint has to do with mistreating litigants, being disrespectful in court, abusing people in court, misusing the contempt power. But there are certainly plenty of cases where people are found who have failed to recuse themselves. But I think the key is absolutely transparency. I mean, they have to, the public has to be able to see what they do. And, it's not perfect because sometimes the public doesn't understand. If you looked at take 1,000 complaints, 950 of them are going to get dismissed because what people were doing is they were complaining about the outcome of their case. And that's not a basis for judicial discipline, it's a basis for an appeal. But the other 50, I mean, then you really got to look at those and say, did the judge mistreat people or did the judge act unethically? And I think, that's where the focus needs to be. But transparency has been the key to that.
And as Judge Fogel and Judge O'Brien spoke to, in addition to the legislature, the courts have significant power here to set these rules. And as while the majority on the Ohio court may on its face seem like they wouldn't be amenable to this, a Chief Justice in her last term might be open to good government reforms that will reflect well on the judicial branch. The petition in Wisconsin did not succeed because of who was on the court at that time. It's terrific policy. It's a model for the nation to follow if other states would adopt it. And so, it's worth thinking about whether this court in its current makeup would be open to those kinds of reforms.
Excellent. Well, I think we are, how about we close with if there's any other questions or final comments that our presenters want to make before we move to the take action part?
I guess I would say, I would encourage folks, I know that this is a topic that can be discouraging, but I would encourage folks not to lose heart when it comes to issues like this. We, as voters, have the power to decide who sits on our courts in Ohio and North Carolina. And I think that, as other folks have said, voters should use that power to make sure they have judges who are going to respect the ethics rules and not hear cases where they have conflicts of interest.
Judge
think
Fogel?
yeah, the only other thing I'd add, and it really just picks up on something that Doug Keith just said. It's easy to get cynical. It's easy to think that every judge is going to be partisan and political and going to make every decision on that basis. I don't blame people for thinking that, because there's plenty of evidence to support that. But it's not true of everyone. And you can find people who really take the judiciary seriously. And, I'm an observer of this nationally. I'm not going to comment on any particular judge, but I could just say, even in some of the most polarized, most partisan blighted states, there are people who care about the independence of the judiciary. They care about the rule of law. They care about the values that made people respect the judiciary in the first place. And it's good to try to identify those people and try to find common cause with them somehow, even if they're not a member of the same political party you are. I think there's opportunity there too.
Wonderful. Judge O'Brien?
Just to follow up on that, I think sometimes judges are criticized for not voting their politics. And I think when that happens, it's important for the public to support them. I'm in a very liberal county, and I think, and it's the state capital, so a lot of important lawsuits are filed here. And I think people assume that the liberal outcome will always be the result, but it isn't, because the judges are following the law, and the law doesn't always provide for that type of outcome. And then they're criticized because they made the wrong decision. So I think the more we can talk about how judges are supposed to make decisions and how most of them do make decisions, the better the public understands that.
Doug?
I think all of these are great final words. Maybe I'll just say that the time to think about this is now, as you all are doing it. It's hard to talk about the court sometimes because it just seems not that interesting to folks. It's not the issue, it's the procedure. But then when the time comes and a court's being asked to overturn an election result, you're going to wish that you had strong ethics rules to make sure that that decision was the right one. And so I really appreciate what you all are doing here. And I hope you continue to think about it.
Well, thank you all to our fantastic panelists. I think we've got a few more slides as we wrap. All right, so as we said, there are lots of ways for us to feel overwhelmed by this, and hopefully Doug wasn't, forecasting into the future about courts being asked to overturn election results in 2020. We'll all start sweating here. But, in 2022, we've got really important judicial elections coming up. So, we've got 2 seats on the Ohio Supreme Court plus the Ohio Chief Justice. And as we mentioned in the chat, the Chief Justice has the ability to make those decisions about whether judges should be recused, what should be recusing themselves or not. So that Chief Justice position is terribly important. And so that, as Ohio is electing judges, we have the power as voters to hold them accountable. And we have the power as voters to ask of our judicial candidates whether they believe in recusal and the need to avoid the appearance of impropriety. So we can be pushing this question and pushing this as, a really sort of a litmus test for what makes for a good judge. Certainly consult judicialvotescount.com to learn all about judicial candidates in your communities. If you're an activist, other ideas, writing letters to the editor, this issue of recusal is not very well known among the public. So the more that we can do to amplify this issue as a critical piece to our, democracy reform, the better it is that we're going to be able to make progress. So please consider sending in letters to the editor. And I know we've got a few, there may be folks who are affiliated with organizations on this call. Feel free to please join us, join the Ohio Fair Courts Alliance. We want more organizations, more allies so that we can be stronger in pushing for these reforms. And last but not least, if there are judges on this call, we certainly want you to be talking to other colleagues of yours, to be talking about the need for, avoiding the appearance of impropriety and being champions of recusal in your circles. So there's plenty to do. We're just getting started. We've got more actions to come up in 2022. Next slide. As Jessica mentioned at the start, we have lots of background and resources and materials that we are going to be sending to you after this concludes. And so be on the lookout for your email with all of the slides and links there. All right, well, there is, I think, one more slide. Okay, yep. We've got a webinar coming up December 9th, just next week. Feel free to register. We want to make sure that you're here to hear all about the intersection between race, law, and democracy. We've got some really great panelists lined up. Kyle Strickland with the Kirwan Institute for the Study of Race and Ethnicity at The Ohio State University. We have retired Judge Ronald Adrian, who will be speaking and joining us. We have the Reverend Raymond Green for the Freedom Bloc, and we have Maria Bruno from Equality Ohio, who are going to be pitching in and talking about the need for eliminating structural racism and getting better diversity on our bench. So please join us on the 9th. Okay, I think that's all we have for tonight. I appreciate everyone's engagement and participation, and I hope to see you at the next event on the 9th. Thank you, everyone. Thank you,
Thank you so much, everyone.